Welcome to Unsafe at Any Click, Internet Safety Lab's podcast exposing and exploring unsafe software behavior. This week, we talk to Julie Liddell, founding attorney at the EdTech Law Center. In this episode, we gather insights on the legal side of privacy for students and parents as it relates to EdTech, and so much more.
So welcome to episode number 5 of Unsafe at Any Click. And today, Bryce and I are very happy to welcome Julie Liddell from the EdTech Law Center based in Austin, Texas. Did I get that all right? Because I actually went and hid the notes. Yeah, I did get it right. Julie, welcome. Thanks for being here.
Thank you. Glad to be here.
Yeah. So today we're going to stray into the dark side of the law, the legal side, which is not our forte. For anybody who knows us, they should know that we are, geeks. We are technical, tech heavy, I will say. And so this will be us dipping our toe into the legal side of things. And so, all right, so let's just dive in. First of all, Julie, give us a little bit of your background.
Sure. So I have been practicing law for close to 15 years, and I started my practice doing appellate law, which is the nerd law of the law practice, and was very content doing my nerd law practice. I worked primarily for courts, the high courts in Texas, for about a decade, just doing research and writing and issuing opinions. And about 5 years ago, I got involved in this space, kind of looking at kids and how they're being affected by screens. And so I've spent the last 5 years or so very, very involved in that space, doing a lot of research, a lot of advocacy, not as a lawyer, but just as a concerned parent. And so I've been involved in a lot of coalition building and trying to work with school administrators and sort of show them all of the growing body of research that suggests maybe this stuff isn't as great as these companies let on. We've developed relationships with state and local lawmakers, and we have relationships in the Senate and with federal agencies. And essentially, it's all been a strong effort, and I feel like at minimum we've raised a lot of awareness around the issue. I think parents especially are much, much more informed and educated around the harms of the internet and screen time than they were certainly when I first got into this. We just haven't seen a lot of real change on the ground. It kind of seems like it's very much the same problems still exist as they did when I got involved, and if anything, they've gotten worse. So that's why I've decided just about a year ago that litigation was kind of the last lever that we haven't tried to pull. And so that's what we're trying to do. And we've got a couple of our first cases on file this past May, with plans to get many, many more on file and let the courts take a stab at this and see, just trying to use the laws that we have on the books, see what the courts have to say about what these companies are doing in schools.
So no more Miss Nice Person.
That's right.
like it's time for the stick, right? I mean, it's time for the legal stick, because so I'm paraphrasing here, but what I'm hearing is that we're not seeing the changes we need to see or want to see, so it's time to ratchet it up a little bit and see if we can get some change out of the supply, which is really what we're looking for. What do you think? What for you are the most serious harms in technology, and what types of technologies that kids are using?
Oh gosh, I mean, that it really could be its own show. So I will try to keep it brief. So looking specifically at harms as they affect kids in the classroom, I think you could kind of start with the most immediate, sort of visible and concrete harms, which are access to wildly inappropriate content, right? It's porn, it's ultra-violent content, it's communications, it's predation through social media platforms that kids have access to. It's things like digital distractions, the fact that kids are messing around online and playing games or on social media or chatting with their friends instead of learning. It's killing kids' ability to concentrate and killing productivity, causing behavioral problems. And we hear that from teachers all the time about trying to manage a classroom of kids who were doing who knows what on their computer is next to impossible. I think there are physical health harms from kids sitting at laptops all day. I mean, that's an ergonomic nightmare. We're having skyrocketing cases of myopia and other eye problems and spinal pain and joint pain and things that 10-year-olds should not be struggling with. But then I think, there's sort of the more invisible and I think insidious harms around the gamification of learning, the fact that kids are now just learning rather than mastering the skill or the material underlying the program. They're just learning to master the program itself, which is terrible for learning, for cognition, for development of critical thinking, creative thinking. And that's only getting worse with the rush to implement AI into everything. And this idea that you type your question, the information you need into a box, and then magically the answer appears without kids having any idea where it came from, what the source is, how to question that source. It's just terrible for critical thinking. There's algorithmic profiling. If we want to get really nerdy, the big problems around algorithmic profiling of kids, from all of this just reams and reams of personal information that's being collected by these companies and sold not just back to the school, but any number of third parties who are very interested in having these highly detailed personal profiles on kids and using it in a host of ways that can hurt kids in serious ways without them ever even knowing that it happens. It's also the constant surveillance. It's kids learning that privacy isn't a thing and that they shouldn't expect that and they shouldn't respect that in other people. It's leading kids to seriously self-censor themselves and learning that you can't make a mistake lest it haunt you forever. That's devastating for all of us, but especially kids whose brains are just forming. It's destroying kids' ability to interact with each other, to have social time, to be able to have a face-to-face conversation with their peers and with their teachers. I mean,
it's so awful. Like
I could go on and on.
I know. I'm only laughing because I'm like, dear God, it's never going to end. It's so like bad. There's just every facet of this. So you're making me think of a couple of things that we didn't talk about beforehand, but I'm going to ask you about anyway. I'm going to ask you about the anxious generation and the controversy, because I do believe it's controversy. There is a lack of agreement on the science and what science is telling us about some of these more difficult to measure causal relationships between technology and people, children in particular. So I wondered, first of all, if you had a point of view on that situation, and no is a perfectly fine answer, by the way. But yeah, that's my first question, and then I'm going to go into another one.
Sure. So I, like I say, been at this for 5 or 6 years, and I can remember the first book that came out that really started stirring up some controversy was the book iGen by Jean Twenge. I hope I got her name right, but it was essentially the precursor to the anxious generation, and needless to say, the science back then was much thinner, and yet what she was saying was resonating with so many people who were attuned to the issues at the time, because I think for so many of us, for most of us, it's kind of the proof is in the pudding. We see it in our own kids, we see it in our friends' kids and our other kids in our families. And so I think many of us feel like we don't need that rock solid scientific evidence to prove what all of us are kind of know in our gut to be true, that something is wrong here, and that there has been this serious shift in how kids are growing up, how they're feeling about themselves and about each other, and how they're spending their time, that isn't good. And I think 6 years later, there's the evidence. It's not like there's this significant body of evidence that has come out that said, oh no, actually we were all wrong. It turns out screens are pretty good, and maybe there are some trade-offs, but by and large,
I have seen that though. I think out of Oxford, I mean, there's been some meta-analysis out of Oxford that is at least raising question about, I think mostly the causal relationship, and that like it's not all bad. Like there are benefits.
It's a guy out of Oxford whose name I'm blanking on now, but it's like a research, and just in all disclosure, it's not anything that I have done a deep dive in to see what that research is, how was it done, who's funding it. It's just that I know as a, on balance, the research that's coming out from all different places is tending to show the kids are not doing well and things are only getting worse. And so I think as parents, especially, we feel like we can't wait around for the definitive science to emerge, which we in our gut know eventually it will one day. It's hard to do for a variety of reasons, not least of which those who control that information, the companies who have that information, are very intent on not giving people access to it. So that's a big part of the problem. But I think as a general matter, parents are saying, we can't wait. We are convinced, based on the research that's out there, and more importantly, our own lived experience, that this is a problem, and that there is a direct relation to kids' use of screens.
Yeah, let's do a quick informal poll here amongst us three. How many of us feel like we have caught ourselves in addictive behaviors with technology? I'm saying that pretty broadly, but yeah.
100%.
Yeah. So that lived experience, I think if we're even a little bit self-reflective and, picking up our phone first thing in the morning or last thing at night, doom scrolling or whatever, or even binge watching, like there's all different kinds of ways that we're addicted to technology. I think, anecdotally, not scientifically, but, anecdotally that I agree that there is, we just look to our own lived experience of this and we can feel some of this. Do you feel as a lawyer there is enough science to defend in court?
It's a great question. And the honest answer is, I don't know. We are going to find out. This litigation right now that's underway, that's been brought by the good people at Social Media Victims Law Center, is raising that very question.
That's right.
That will be adjudicated, and I certainly hope that there is enough to support their claims, but we'll see. But I'm so happy that there's now at least going to be a forum to have that conversation and to put that evidence to test and let both sides, give their best effort and put their best studies forward. And let's let a judge weigh in and decide where the evidence lies. So we will. Yeah. The answer is I don't know, and we will find out sooner than later.
Yeah, good. So I have another bonus question that I don't know that I teed up. Sorry, it's all now that all the wires are connected now. But I'm wondering, I want to ask you about your thoughts on the Surgeon General's call for specifically a warning label on social media platforms. How did you feel about that?
I think it's warranted. I think I'm very, very happy that he weighed in, whether it happens or not. Again, I think it's all awareness raising, and no matter what happens with it, I think whether that actually happens, however this litigation comes out, I think parents now are becoming ever more attuned to the fact that there's a good chance that these platforms are dangerous, and at minimum they need to be very, very mindful about letting their children use them. And so I think it's all a good thing. I think more information, more awareness is absolutely the right direction. I don't know when it was when the Surgeon General warning was required on tobacco. I can't remember if that predated the litigation or not. But the point is, I think they're.
I don't think so. I think, was it under Coop, Surgeon General Coop, who did it? I don't know. I feel like it was in my lifetime, which granted is long. So it's not really limiting the scope at all. But
so it was all those efforts, though, right? That woke us up about the harms of tobacco, of cigarette. And it wasn't just the Surgeon General's warning. It was the litigation. It was the information campaigns. It's been a lot of things that now we're to a place where I think our kids, I mean, even people in my generation look back and think, oh my God, people smoked all the time, like in cars, on
planes.
My
God, on planes. That was like the
bananas.
Most miserable. Yeah. Well, okay, so I just want to let you know that we wrote about the Surgeon General's thing. We actually do not agree with a warning label. We advocate for a label, an information label, because I think, I read some of the pushback on, like, from, social scientists and people who are much smarter than I am about this stuff. And they talked about, like, the impact, the heft of a warning label. And I do sort of feel like maybe we're not at the scientifically supported point where a warning label in tobacco is like, these substances measured have been found to be addictive. And I think that there's like a really, repeatable process where we've identified the risk in it. And I feel like we're not quite there. And I also feel, and that can be debated. And maybe I could be easily wrong on that. But I think the more important piece, and I heard you say this, but maybe not in so many words, is it's all about the transparency. It's the fact that people deserve to know what the risks are. Coming to a collective agreement on where the thresholds are, we're a long way away from. We struggle with that all the time in our safety labels. This would be a good time to put up our safety labels and also a link to our Surgeon General response. But yeah, we think a safety label is absolutely warranted, and that people should know that, yes, these certain user interface tactics have been proven to be addiction fodder. Anyway, so that
could be the right approach for now until we get some more definitive evidence, whatever that looks like, whether that's through this litigation, whether that's through just you reach a critical mass, a critical number of studies that show that really do definitively show the causation.
Yeah.
Then maybe that's when it flips, and from here's information to here's a warning.
Yeah,
but
exactly.
Information is transparency. That's the key.
Yeah. So let's talk about transparency, and let's shift our gaze over to the law, especially as it relates to children and children's information. And is the law, and so we're going to spend time talking about COPPA. And I think we should also touch on FERPA a little bit, because one of the things that we teed up in our research, on our EdTech benchmark research, was, there's a lot of confusion in schools about which law, how do you comply with the law? And so let's open the question of, maybe let's start with, what is COPPA supposed to do?
Sure. So COPPA is the Children's Online Privacy Protection Act, passed back in 1998, a little bit before the modern internet had taken hold. But essentially what it does is it provides greater protection to kids' personal information online, and provides parents greater rights to that information. And so it looks like, so this applies to internet operators who have actual knowledge, is the standard, that children under the age of 13 are using their platform or product or service. And if they do, then that triggers COPPA's requirements of notifying the parent, and parent broadly defined as any legal guardian, and obtaining their informed consent. And once that happens, then there are additional protections around parents' rights to be able to, number one, revoke that consent, but also review and access the information, and also there's another piece. Oh, and then additionally, there's a data minimization provision and heightened security requirements for handling kids' data. So I would say at a high level, those are the goals of COPPA and what the additional protections that attach when an operator has reason to know that a user is under 13.
I want to just poke into that a little bit. Actual knowledge. Tell us what that looks and feels like in practice.
That is a thorny question. And
that's why I'm asking it.
Absolutely a hot topic of debate in the courts. What does that mean? When can a provider be known to have actual knowledge? And I think I have to limit that to my area of expertise, which is in the school setting. So I would say if an operator is operating in a school setting, especially in an elementary school setting, that is actual knowledge. You know that the kids who are using your products are under 13. Beyond that, it gets tricky, and that's I think definitely something that the social media litigation is wrestling with, is around these kind of age verifications, kind of this idea that you can say that we don't know age verification because we're an anonymous platform and we don't request that information of our users. And indeed, in our terms of service, we say, don't use this if you're under 13. And yet we kind of all know that these companies have that information, even if kids aren't inputting it directly. But it's a question of just proof, right? It's being able to show this company actually does have the data that would show they are 13, but then it becomes a question of maybe the data exists somewhere in their database, but does a human, actually know that exists? Like so that it just gets into a very, very thorny question of proof, of showing that an operator does have actual knowledge.
I have to sidebar it back to our identity resolution, because I think it's such a fascinating thing that there's like sort of two simultaneous realities going on. And one is that, there's this commercial infrastructure afoot that absolutely is identifying every single actor on the internet. Every single actor on the internet is being identified, including most likely knowing the age of them. And they do it for commercial purposes. And I think the vast majority of the entities that plug into these infrastructures, which is just about everybody, to be clear, they know exactly what's going on. They know what they're doing. They know the volume of information that's known about these actors, these users on the internet. So I find it very interesting that there's this sort of like amnesia world also of like, we can't possibly know what their ages are, and so it's a thing. Bryce, you were going to say something, and I want to hear what your question was.
I think I was just going to bring up the point of, it's not what you know, it's what you can prove, right? We know that they have actual knowledge, right? Based on what we see, what we saw in our benchmark, what we see in all of our audits. These are apps that are in schools, largely in schools, and being used frequently in schools. We know they have actual knowledge that they are in schools, but being able to prove that they have that knowledge is what becomes difficult.
Yeah, it's a weird thing to codify in law, actually, because like it's basically saying we have to prove what's in somebody's head somewhere. Knowledge lives in people's heads. I mean, it's documented, sure, but it's, also, I don't know.
But it brings to mind criminal law, right? Where most criminal statutes have a mental state requirement. And juries they make decisions around mental state every day in this country. So, and by and large, you're not going to have somebody saying, yep, this is what I intended. You have to do it circumstantially, and it can be done. And so I do think it can be done with these companies in the same way, but it requires lifting the hood of their operations, which they are very disinclined to do. And that's what makes litigation so important, because we have a process for doing that. And so I do think, again, I come back to the reason I'm here, or the reason this firm exists, is because litigation really, I've come to believe, is the best process for trying to get at these questions.
Yeah. So what do you think are the biggest misconceptions about COPPA?
I think there are a couple. I think one is that parents can seek to enforce COPPA themselves. They cannot. There is no private right of action in COPPA. It may only be enforced by the Federal Trade Commission or by state attorneys general. So that has proven very challenging for parents who say, I asked a company, I know that my child has been using this platform. My child's under 13, and I have reached out and said, my child is under 13. They don't have my consent. Don't let them use this, or I want to see what information you have, and have gotten absolutely nowhere. So we know that companies are not complying with COPPA across the board. And yet there's very little that parents can do other than filing a complaint with the FTC or seeking help from their attorneys general. And unfortunately, that just hasn't been a very effective enforcement tool. The other, possibly even bigger misconception about COPPA is that when it comes to schools, when operators are selling and marketing into schools for use, EdTech companies, that COPPA basically goes out the window, and that none of those requirements apply, because their position is that the school essentially takes the place of the parent, and that as long as they get a school administrator or IT person or even teacher to sign something or check a box or even just use their services, that essentially they're doing that, they're providing consent on behalf of kids without any notice to or consent by parents, or even over parents' express objections. And that gives them essentially unfettered access to the personal information of all of, thousands or even tens of thousands of kids.
So let me ask the question. Can schools consent on behalf of students for using technologies?
No. Not if they collect and use, not if it's a private company and they collect and use children's personal information. Under the letter of the law, schools cannot consent to that without some agreement with parents that they may do that.
So this, I think, is such an important thing. We're going to make like a little excerpt of that, of you saying that, and we'll publish that, because we certainly saw it all over that in our research in our 2022 benchmark, that I think it was Virginia Beach, had a site of like 500 or 600 domains, URLs, like for, usatoday.com, newyorktimes.com, whatever, americangirl.com, like whatever, all of these things. And they said at the top of this, we are consenting on behalf of all of these things for your student to use this stuff. And we flagged it because we knew it was not okay. It was not okay for even if the law allowed the schools to do that, it was clear that the school was not managing a relationship with all of those websites. Like there was no, these were autonomously used sites. And this also kind of bleeds into another issue of, we see a difference between the technology that schools are licensing, and like taking great care and procuring and screening, presumably, and then deploying and managing. But the vast majority of technologies that children are being, or students are being directed to are not those. Like that's the tiny part of the list of technologies.
Absolutely. Yeah, that's absolutely right. And even with respect to those, according to the law, they would still need to obtain parental consent in order for these private companies to take and use their kids' information. So, there's all kinds of issues with consent as conceived by the schools and by the companies themselves. Number one is the question of who has authority. Is it the school, and if so, by what right? My position is no. There is no law that gives the school that authority. COPPA says absolutely nothing about schools. There is nothing in the text of the statute of COPPA or in the implementing rule by the FTC that even mentions the word school. So
what about FERPA though? Because I think there's some confusion about this, because in FERPA, right, there isn't there actually a call out that says that the school can consent for academic use and certain other uses like nutrition and I don't know, whatever.
Yeah, so FERPA, the Federal Education Rights and Privacy Act, again, like COPPA, its goals are to protect kids' privacy and their personal information and their education records, and grant parents greater rights to that information, to review, to access, to determine who has access to it. So I think it's important to start there, that is at its root a privacy law that these companies and schools, unfortunately, are reading as a privacy undermining law. And the way that they're doing that is by reading there's a very narrow exception in FERPA that's called the school official exception. And let's bear in mind, FERPA was passed in 76, so 50 years ago. So it was passed in a time when school had school records that were like in a filing cabinet. And so what FERPA says is schools, and it only regulates schools. This does not purport to regulate private parties. It's only regulates schools, and its only enforcement mechanism is withholding federal funds. So schools that don't take federal funds actually don't even have FERPA requirements. Now, I will say, since FERPA has been passed, most states have some, version of FERPA on their books. But as far as FERPA itself, it is only a law that is intended to regulate schools' use and disclosure of their own school records. So let's start there. It does not contemplate a school authorizing a third party, a private company, to come in and collect information directly from students. So in that sense, FERPA is just the wrong framework to even talk about this stuff. But let's just even assume that FERPA was applicable. It does have something called the school official exception, which says that schools may disclose personal information from education records under very limited circumstances to a school official, which of course is thought of as a substitute teacher, a bus driver, a school nurse, somebody who is closely affiliated with the school for a narrow, legitimate educational purpose, and they only can keep that information for as long as that purpose requires. And so that's what's happened, is that these companies have swung in on the chandelier and saying, we're a school official, we're only taking this stuff for an educational purpose, and so we don't actually need to get parental consent, or rather the school doesn't need to get parental consent for our taking kids' information. But that's problematic. Number one, again, FERPA regulates schools, not private companies, so these companies cannot use it in the same way that their FERPA, like COPPA, does not have a private right of action. Like you and I can't go and say the school isn't adhering to FERPA and sue. We have to wait for the Department of Education to do that, which I don't know that I'm not sure they've ever brought an enforcement action under FERPA. I hate to say it's dead letter, but there's certainly not robust enforcement around it. But in the same way that we can't sue to enforce our rights under FERPA, a private company can't use FERPA as a private defense to non-FERPA claims. I mean, that's just a crazy position. So that's the problem one. The other problem is, even if they could, they don't meet the definition of a school official. A school official is narrowly defined as an entity or person that is closely controlled by the school. Well, that doesn't define these companies. Schools have no control over how these companies operate and how they take information and what information they take and how they use it. Schools are almost as in the dark as parents are on those issues. And they're not just using it for a limited educational purpose. I think what their position is, well, we're EdTech, so anything we do with it is an educational purpose.
Yeah.
But that's not, if words have any meaning, then that was not the original intent of when FERPA was passed back in 50 years ago.
Yeah. This is also I heard a little bit of echo there, but this is reminding me of the dual controller confusion issue that we raised a few years ago, where schools are in a very tricky situation. And in fact, we talked to one EdTech provider who made it clear that they were providing technology to the school. They were providing a platform to the school, and it was a hands-off relationship from there, and that the school the LEA was single-handedly the data controller. And this makes no sense to me, because the school didn't build the software, and the software is the thing that is, sharing information with processors and doing, so all of the decisions and the design and the implementation of that software seems to obligate the platform provider with, under GDPR anyway, like a dual controller kind of role. And that has not, I think there's a lot of he said, she said kind of thing happening, relying between the vendors and the LEAs, that is, in my opinion, unfair, because and silly. And what this one vendor told us was that they were like, well, Section 230, we're not responsible. We just provide the platform, and so anyway, that's another interesting topic to me. And there's lots of these like this. It's not just schools. It's also like medical institutions that use, personal health records and things like that. Like, they don't write the software. Mm-hmm. So who's responsible for the integrity of the personal information? So, and I don't know if you have any thoughts about that.
Well, and I absolutely appreciate what a difficult position schools are in. They have tremendous pressure to educate kids, to make sure that they're staying, up to speed on the latest and greatest in technology. In some cases, they even have mandates where they're required to use these programs, or strongly encouraged to use certain programs. I mean, it's just been this huge, hard and fast push toward ever more tech in the last 10, 15 years. And so I can't appreciate that they feel like, what are we supposed to do here? We're between a rock and a hard place. We have to use this stuff. And yet I think many of them know it's very problematic for a host of reasons. It's kind of gets back to these harms of the immediate harms that we and teachers, on the front line see every day. And then I think, they have a sense that there are serious privacy harms too. Parents do have a right to what happens to their kids online and what tools they use. And yet it just kind of feels like schools are taking the position now of sort of closing their eyes and holding their ears and just saying we
I think holding their nose is the right analogy. Right. I mean, it's like they know it smells bad, but there's nothing they can do about it.
That's
very
right.
little.
And I really wish that school districts would take a stand more in favor of parents and kids more than they are, and say, we agree that schools need to be learning technology. They need to know how to use these tools. We need better tools to teach them, because these tools aren't safe. These tools are not designed, they're not optimized for kids, for safety, for education. They are optimized to collect data. By and large, that's most of these products. And so this doesn't work for us. This isn't legally compliant. And so these companies need to make products that are for us, that are for this intended purpose, this intended user, and they're not right now. And I think schools absolutely have claims against these companies for false advertisement, deceptive trade practices, for product liability, for saying, maybe we know now more than we knew then, but back at the time that we signed up for this, we had no idea what these tools actually were and how they worked. And so I would love it if administrators would just start taking a different posture and starting to side more with kids and their parents than they currently are, because right now, unfortunately, by and large, they're pretty adversarial and even hostile to parents who are speaking out about this.
Wow. That's not great. So one of the things I want to tie back to, going back to COPPA, is, in our benchmark, one of the things that we looked at our deep analysis of what the app was really doing compared to COPPA Safe Harbor certifications, other certifications, the Student Privacy Pledge, the SDPC's data privacy agreements. And we weren't suggesting that all of these things were trying to accomplish the same thing. But just to underscore that, I know there's been some confusion about that out there in the world, but we were curious to see, okay, what are these things doing relative to what we were seeing and how we were looking at it. And the COPPA Safe Harbor apps, they pretty much, from our research, it seemed pretty clear that they were pretty effective at removing behavioral ads. But those apps on the whole, as we've seen, and I don't think we've released this research yet, this is like a new bit of analysis on the network traffic. But what we saw is that the Safe Harbor apps were actually sending data to more third parties than the overall population of apps. Yeah. So my question is COPPA working?
No. No, it's not. Right. There's no enforcement. So no, it doesn't. And that's kind of how I feel about the laws that are on the books, the laws that are being proposed. If there's no private right of action, there's not going to be any enforcement. And so you can have the absolute world's best, most perfectly crafted, wish list law, but if there's no meaningful enforcement, it doesn't matter. So, and right now, because pretty much the whole world is operating under this mistaken belief that COPPA just doesn't apply in schools, then it hasn't been enforced. I think the FTC has brought one enforcement action against an EdTech, a very small EdTech provider, sometime in the last couple of years, a small player in the space. And that's it.
Edmodo? Was it that one?
It was Edmodo.
Yeah.
That was the one. Yep. And otherwise, that space, there is no oversight, there is no accountability. And so that's why you've seen this industry has exploded into EdTech is something like a $500 billion industry or something approaching that. And you'd like to think that was just like private equity, very excited about the latest innovations in K-12 information management and storage. But call me cynical, but I think there's something else going on there.
Well, we know there's something else going on there. I mean, it's not cynical. This is the oxygen that we live and breathe in, and we see, and so this tees me up for the philosophical question I have to ask every guest that comes on, and the reason for the cynicism is that this student information is being hoovered up by commercial surveillance infrastructure. It's indiscriminate. It picks up data from everybody all over various transactions. It does it in bulk from services directly. It does it in transactional based things from, JavaScript pixels and real-time bidding protocol. It's just, it's unavoidable, and it's indiscriminate. So it's absolutely picking up children's stuff. If you look at LiveRamp, I gotta like pick on them at least once every podcast.
They deserve it.
So LiveRamp is a data broker, and they are ingesting the data of a lot from hundreds, like probably over 1,000 sources. They're ingesting data from. And they say, and if you look at their like public filings and stuff, that they absolutely are ingesting the data of children. So they are a data broker, and they are ingesting the data of children, all of which leads me up to my philosophical question of, what do you think about the monetization of personal information? Is this a thing that serves society and humankind well, or?
No.
I guess that was a bit of a leading
Option
question.
B, whatever it is.
Yeah.
I think it's been devastating. I think it's been absolutely devastating to society. I think this business model, this data collection business model, has had more deleterious effects on us individually and societally than we even appreciate. I think it's going to be something that in the future, maybe in the hopefully not so distant future, again, we look back on and just say, wow, that was really destructive.
Like smoking.
Right, that's right. I mean, that is the heart of Shoshana Zuboff's book on this very topic, on surveillance capitalism, and talking about how destructive it is to everything that we know, to our values. And it is at the heart of, we see all of the externalities that look like screen addiction and compulsive use, that look like access to harmful content and exploitation of children and predation and polarization of our discourse. All of that is disparate as it feels, I think, can be fairly linked back to this business model.
Feeding the machine. Yeah, keep feeding the machine.
That's right. It is absolutely about keeping people using at all costs. And they have gotten very precise. They have engineered ways of doing that are so effective that I do think tobacco is jealous. If only we could roll that up and have people smoke it, we would really be in good shape. But it really is these design techniques that prey on the most primal parts of our brain, and it is horrible for us as adults. It's devastating to a child, to a developing brain, and it's horrifying to be a parent right now and seeing that these new risks posed to our kids, these very fundamental and insidious and invisible risks that our kids are having to navigate. In addition to all the other things that we've had to worry about as parents, those haven't gone away, but now we have this whole new monster to fight, and it's really, really scary, and it makes me very angry. If I'm going to be honest, it makes me really angry that these companies continue to do it, despite that they know the harm that they're wreaking on society and on kids in particular. And it doesn't matter. They just take it to the bank. And I know that they have all the different ways of rationalizing it and all the different things that they point to say that look at all the good that has come. But it's unfair. They don't get to make that choice for us. That should be a choice that we get to make as a society, to decide if that's really the trade-off that we want to make. And right now we've had no say in it. I mean, this is just now the cost of being online. And right now being online is a requisite to being a member of society. So I don't even think the idea of consent online doesn't even make sense, right? I mean, we talk about it in the context of education, where of course it doesn't make sense because education is compulsory.
Yeah,
so
exactly.
As long as rules are a required part of education, consent doesn't even mean anything. It's not voluntary. But I think that applies more broadly when the fact is you have to use these services and be subjected to these practices and to these dangerous design elements to do anything, right? To get insurance, to get a loan, to apply for school, to pay your rent, on and on and on. Is this really voluntary? Can you even call our use of these services voluntary?
That's right.
As necessary to support consent? And I think that the answer is resounding no. So these are issues, though, that are being litigated in the courts, and I do think that the courts, the orders and opinions in the space are trending in the right direction. I think courts are getting more serious about consent has to mean something. And, I do see this litigation specifically in the school space as very important, starting to define what consent does mean online, and is that even possible, to start getting at those more important questions of, is consent even possible in 2024? And I honestly, I think the answer is no.
And by the way, we talk about that all the time. The previous podcast was a whole, dialogue on why consent is absurd and not fit for purpose, and written things on it and all of that. Anyway, but what I'm wondering is, there's no serious movement. The data broker laws are a joke. We also talked about that last time. There's no serious movement to actually prohibit this behavior, this harmful behavior. And there's a lot of reasons, but mostly they are commercial reasons. They are money-driven reasons. Whether it's lobbyist or whatever, right? It all kind of comes back to preserving the status quo, preserving the money flows in the way that they are today, safety be damned, really. Do you think, though, what I heard you saying made me think, do you think this could be death by 1,000 cuts with case law? Can we chip away at this to ultimately get to safety without having to try to come top down with something that will never manifest?
I have to believe that's true. I mean, I do that, or else I wouldn't have upended my nice little quiet appellate practice to jump into this morass. I do think that it is the way that it will have to go. I wish that wasn't the case, but having been at this for as long as I have now and trying all the different things that we have, I do believe that it's the case, and I feel optimistic about it. Cautiously optimistic, but hopeful. Because like I said, the courts, the orders, the opinions that are coming out, they are. It's slow, but they are trending in a positive direction, and a direction of, if these laws are going to mean anything in the digital age, then we've got to apply them accordingly. And so I am very excited about bringing these cases in the context of education, where you're talking about, number one, children, and number two, a compulsory environment. I think that very much sets up nicely a context for judges to start getting serious about what our rights are online, that I hope we can then use to sort of parlay into, well, if that's right for kids in a compulsory environment, then let's talk about adults in environments that maybe, while it's not letter of the law, that they're compulsory, are, de facto compulsory environments. And so we'll see. It's a long process. Litigation is much longer and slower than any of us wish that it was. But at the end of the day, a court does have to rule on issues. There is a process. They can't just languish in some committee forever. They have to be resolved, and there are mechanisms for doing that. And so that's where I'm putting in, my money, my time, to these efforts, and we'll see how it goes. But there's definitely a big vocal group of us who are jumping up and down and doing what we can on this front to get some good law, in our favor.
Yeah, one of the things that I'm optimistic about is seeing more of the product liability stuff coming out and tying liability to these, what I call a software product. I know that's not language that the world agrees with. And this is actually relates to, so It's awkward. This is an awkward moment, but I am a Harvard Fellow with the Democracy or, Surveillance Capitalism or Democracy inaugural fellowship cohort under Shoshana Zuboff and Matthias Risse. And my project is about product safety as a natural antidote or resistance to surveillance capitalism. And part of that has to do with reframing what are products in the digital age. I think this is a big thing. I don't have any answers on this. I'm just kind of setting up an observation, is that what do we consider products in the digital age? And a hammer and an app are both tools, but they behave very differently. I always say there's an animating force in software. Software is the animating force, which makes these things different than these inert things. But our product safety laws have not advanced. The last time the U.S. Product Safety Act was updated was 2008. So it is not equipped for the job. I wonder if you have any final thoughts on, is this a worthwhile avenue? How much should we invest in pushing for updated product safety and product liability in the digital age in the U.S.?
Yeah, it's a great question, and there hasn't been a lot of use of product liability law to try to rein in these companies and hold them accountable. The Social Media Victims Law Center is doing that. They have brought product liability claims against the social media companies, and it's interesting. The question of what is a product is not clear, is far from clear, and the courts are just now starting to weigh in on it. I know in that case, I think it was a little less than a year ago, the judge took on that question, and it was the order was about, I want to say 70 or 80 pages long. Oh. About defining what a product is. And she came down on the side of, these are products. It wasn't as simple as this platform is a product. Essentially, it was broken out into aspects of the platforms, right? And so it was, what about the filters? What about the parent verification design choices? What about the, there were several things. Is algorithmic content, is the algorithm a product? Without looking at it, it was a very complicated opinion that essentially said you cannot look at it is impossible to look at any of these just as a whole as a product. You have to strip them out and look at their constituent parts and determine whether they individually, are discrete products within a bigger, which you can't call it a thing, service. But she ended up coming down on the side of, I think, saying that it may have been most, if not all, of these constituent parts that were at issue in this litigation were products. And so the issue then was not, are they products for purposes of product liability? It is, are they 230 barred? That became the real sticking point. And
all roads lead to.
Right. And again, trying to make sense of what was 230 barred and what wasn't, take someone smarter than me. I honestly can't and still can't really make heads or tails of what's 230, because it's actually just publishing or hosting third-party content versus what isn't. And I think even that question, you have courts disagreeing. So this was what one court said. Another court, the Third Circuit, just issued an opinion a couple of weeks ago saying algorithms are not protected by 230, because that you aren't just talking about the neutral hosting of third-party speech, but the algorithm in and of itself is its own first-party form of expression that's not 230 protected. Now, there are First Amendment claims implicated there, but it's not 230. And so that's a very long-winded answer to the question of what's a product, and then maybe even more importantly, what's barred by 230 such that you couldn't bring it as a product liability claim. It's a hot topic. It is very much percolating through the courts. My firm is actually getting ready to bring some suits through product liability that are different than what's being currently litigated around social media. I can't really say much more than that at this point, but once we have them on file, I'd love to hop back on with you.
Yeah.
And discuss what is a product and is 230 implicated. But I think there's it. Again, I'm optimistic. I think that it is an underutilized tool, and that hopefully we will start to see more and more lawyers bringing these claims. Because I think like you say, it's death by a thousand cuts. And so whether it's data privacy, whether it's product liability, whether it's just good old fashioned negligence or antitrust or employment cut, there's so many different ways at going at this. And I think we have to just use them all. We've got to just try them all. And if we get a bad judgment out of one court, then we go and we file it somewhere else, because there are a lot of courts in this country. And what one judge decides on some novel issue isn't necessarily going to be what a different judge decides. And it's interesting because these issues don't really neatly break along partisan or political lines. And so you really don't know that it's you going into a court, how a court's going to come down. So I come back to, I'm hopeful. And I love that. I feel very grateful that I'm in a position where I get to do this, where I get to bring these claims on behalf of kids and their parents and start to hopefully move the needle in a meaningful direction in favor of individuals.
Yeah. Well, that's, I think, a great ending point. We've covered a lot of ground, and yeah, we are 100% with you. And, Godspeed with the work that you're doing. Yeah. All right. So that's going to be a wrap for us. Julie, thanks for being here. Bryce, thanks for supporting as usual. And we'll end it right here.
All right. Well, thank you all so much. I really, really, really appreciate it. And thank you both for the work that you're doing in the space. It's absolutely critical. You are doing God's work, and you do not have the recognition or the support that you need yet. But I am hopeful that
yes,
is
hopeful.
hopeful I can even help with that. But just keep at it, because it takes all of us rowing as hard as we can in our area of expertise to make the change that we need.
Yeah. Well, thank you for those kind words. Yeah, we press on because it's an important mission. So, all right. Well, I think that'll do.
Okay.
Thanks, Julie.
Thanks for listening to Unsafe at Any Click, a production of Internet Safety Labs, and join us next time as we poke around under the hood of software to identify, quantify, and expose invisible safety risk. Internet Safety Labs is a 501c3 nonprofit organization based in the digital world. You can support this podcast and other resources by making a donation at internetsafetylabs.org.